Hey everybody, this is Jason McGrath, and this is another installment of Carolina Contracts. In the last part, we talked about arbitration provisions and whether your contract does or should have one. Let's just say that there is going to be an arbitration provision. One of the main considerations that you should, consider up front is whether that should have an attorney's fees provision and how that should work, and as well as costs of arbitration. So, for example, you could have an arbitration clause that requires arbitration but doesn't address attorney's fees or costs of arbitration either way. You could have an arbitration clause that basically says that the prevailing party shall have the ability to recover their costs and fees from the other party, the non-prevailing party. Or it could say that each party will bear their own costs and fees. These are all valid ways that you can do it. And there are different schools of thought on this, but mine boils down to this. If you are the party that has, greater resources, you probably want to have a provision that says that each party will bear their own costs and fees. You also want to look at, okay, who is more likely to be doing the suing here or be doing the complaining here? And if you are the party more likely to be sued, then you probably also lean toward each side bearing their own costs and fees. Um, and that's a little bit more debatable perhaps, but the thought behind those two, preferences is this. If the other side is going to not have a lot of money to sue, they probably are looking for an attorney to give them a discounted rate in order to get some of the money back should they win, like a split contingency fee for the attorney, or a pure contingency fee where they go to the lawyer and say, hey, look, I can't pay you, but I have a really good case against this company, and we're going to win $100,000, and you'll get, 25% or 33% or 40% or whatever it is. And some lawyers will take cases on that basis. I generally don't. But a lot of lawyers do. Not a lot, even perhaps. I think it's overblown. I think it's actually a small amount. It's mostly the personal injury lawyers, and they advertise a lot. So people think that most lawyers do that. Most lawyers actually don't. But if you have greater resources, then sometimes you're going to get into a battle of resources. And does the other side have enough money and enough willpower to prosecute a lawsuit against me, especially if they have no hope of recovering their attorney's fees and costs, even if they win? So, and of course, if you're on the other side, if you have less resources, you may want to have the arbitration clause allow the prevailing party to recover costs and fees in case you ever do need to sue yourself. So those are a couple thoughts and some factors that you ought to consider when determining the details of your arbitration provision as far as costs and fees. Thanks.